Hello, 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 everybody. Hello again. I think things got a little rushed towards the end there. That's all right though. Let me move this here so that it's not totally in the way. Here we go. Did we get it? Get it? Hello, the main event. Yes, that's right. Welcome in, everybody. Welcome. Hello, hello, hello. Hello, Delulu. Welcome. John, Allison, good to see you. Donia, oh my gosh, good to see you. Lee, Alyssa Divine? Alyssa Divine? Ooh, that's a pretty name. I love that. Willie B, hello, welcome. Welcome in. Kimberly, hello. Yes, we're back. We're back. Did Atticus create any nift art on the printer? I tell you what, these cats, they go after the printer. Oh my gosh, it's Pearl. She usually will just sit next to the computer or sit next to the printer and just watch, but sometimes she will grab. And so there have been a few times where the papers have gotten crinkled up or, something's gotten jammed. I think there's only been one time where I saw her actually sitting on where the paper comes out. And, she's not a kitten. So I had to move her. She's an intern. Yeah, she wants to get paid. Oh my goodness. Hello, Cynthia. Hello, welcome. Nancy, hello, good evening to you as well. They are delightfully ridiculous. That's perfectly said, Beth. Perfectly. So yes, this is a new filing that I'll be walking everybody through here. Let me just make sure I've got the exact date here. Oops, that's not the date. That's a different order. Let's look back here at the date. Yes, Jonathan Cooper. All right, let me pull it up here on my computer. All right, so okay, motion to seal has been requested, right? We already knew that. So this was filed, paperless order, Pro Hoc Vice. Motion to, hold on here, let's see. I think it was just yesterday. Yeah, this was filed yesterday. There have been a couple of filings today for Pro Hoc Vice, which means counsel to be allowed into federal court, but nothing other than that. So nothing of real substance. There have been lots of orders granting that. She does, Dawn. She does. I have these like throat drops, and I don't know, like the people that do like the singing and dancing shows on the stage, they said these are the best ones, and I don't know. I mean, they're all right, but I don't know. So if you hear me with the lozenge, there you have it. You attack the mail. Oh, I know. They do. Did the news agencies get those sealed records open? Well, you have to be more specific because there's a lot of them over there. Is she doing my taxes? That's funny. Okay, about the case in Guatemala. Okay, good. Oh, yeah, interesting. Yeah, I'll have to take some more time reading through. We did have a new filing that came down during my live over on the TikTok regarding the Alien Enemies Act. So there was a new filing, and we just kind of ran through it. But if you are interested in that, everyone, this is the case number here, and the case is ASR versus the T-Rump here. This just came out. So it's interesting. We will have to, I'll have to take some more time going through it. I went through it really quick, but that's an interesting perspective. Yes, I have the throat coat tea and then like the sore throat tea. I tell you what, everybody, don't take it for granted if you've never blown your vocal cords out. Just be like, I'm so thankful I've never blown my vocal cords out, because once that happens, yeah, they're never going to quite be the same again. So be careful about that. Yeah, so tonight, am I close enough, everybody? Can you see this? Let me bring this down a little bit more, since our chat's off to the side, and kind of further down. There we go. There we go. Yes, I saw that, J Jack. So do we know now what their new sentence is? Has that been released yet? I'm not sure. We've got we have so much stuff going on. The Weinstein. I know it's Weinstein, but for some reason I always think of Frankenstein, and so I just mix it up. And now every time I'm like, don't say it the way it's not supposed to be said, and so I say it the wrong way every time because I tell myself to not make it that way. You know, it's a self-fulfilling prophecy. 50 years chance of parole. So already served? I mean, does that... So they're just putting the parole in for an option because they've been in there already for like 35 years. Young Winstein. Yeah, it just looks like Frankenstein, right? Okay. All right, excellent. Interesting. Maybe from the bench. Okay. 50 to life. Interesting. You know, that is actually quite unusual for a sentencing like that to be reconsidered. You know, I'm not sure they have a lot of new evidence either that they were looking at. So a very interesting situation with that. Yeah, so we had some testimony today in the Sean Combs case, and that was interesting. I'm not really listening to the details in that case, but I'm watching to see what's happening. Looks like we're going to have some more testifying tomorrow as well. Remember when it was happening? Oh, yeah, I know. That was just bonkers. And, you know, at that time, too, we had such a different understanding of trauma and those kinds of relationships than we do now. I mean, we've just advanced a lot since that period of time. Right. All right, everybody. Well, let's go ahead and dive in. Welcome in. Thanks for coming. I did do a pregame show over on the TikTok, but I am here now. So just to remind everybody, this is my only time that I'm confirming I will be here and be ready. So Tuesdays on the Tube. I think I like that one. Tuesdays on the Tube at 8 o'clock. So I appreciate you coming over. I want to make sure and have some lives over here, because I'm still making my way over here. This again will be my permanent residence. But as time goes on, we're still kind of... Oh, really? Just you? Yeah, this is my third live today. You gotta be tired of hearing from me. Oh my gosh. But yeah, so Tuesday, everybody, unless, something happens and I can't say that it won't, but I wanted to go through the latest filing in the Abrego Garcia case. Right, so everybody remembers the Garcia case where we have the facilitate the return issue going on with the government, and yeah, it's a problem. It's a problem. Now, what has happened in this case is that we have had expedited discovery ordered. Now, expedited discovery is pretty rare in state courts. It's a bit more common in federal courts, but it's still, there really has to be a good reason for it, because the courts aren't really in any big hurry. But this case, we are in a big hurry, and time is really important. So the district judge, ordered that expedited discovery. Now, in her order for expedited discovery, she set out and said you can have 4 witnesses and a certain number of interrogatories and a request for a production of documents, all right? And that's pretty typical discovery. So she set those parameters out, and they have been able to do depositions of the people that have done declarations. And we've talked about this before. Those declarations that have been on file have not been, they've not been great. All right. They're not at a level that's like, oh, okay, yeah, that really confirms everything. No, they've not been great. And this, of course, went all the way up to the U.S. Supreme Court when it came to this question of due process. And the court was like, of course, there's due process, and that needs to be reasonable due process as well. So then it came down from the Supreme Court after they said you need to facilitate. And so this discovery process is also how they're trying to figure out what the government's doing to actually facilitate. There is a requirement by the U.S. Supreme Court that they're supposed to be, doing something. And through this discovery, they're able to ask these 4 depositions, as well as through the interrogatories, like, hey, what are you all doing to comply with the order? Now, because that's happened, there's information that came out that they didn't have before, and which leads us to this memo here that the plaintiffs are filing. One of the things that is being asserted here is privilege, like state secrets privilege is one of them, but there are multiple privilege assertions that have been going on. So the plaintiffs came in and they're like, look, you don't have possible grounds for your privilege requests. And so in here, we've got some updated information that the plaintiffs were able to get through the depositions and interrogatories. And then also, I think it'll kind of give us a better idea about where we're at. So with that, let's go ahead and dive in to what's going on in here. Again, we have the state secrets privilege, which is the same privilege that they attempted to assert in the JGG case out of DC, and the JGG case is now gone because it got kicked to Texas, which is where they're being held, and that's where you need to file your habeas case. So that case is gone, and the court has come in and set the parameters on the AEA, which they're saying, no, you cannot use it here. So here we go. We've got table of authorities, introduction, background, argument. The court should overrule the state secrets objections. DHS and DOJ have not properly invoked the state secrets objections. Oh, thank you so much, John. Oh, you're so sweet. Right. Exactly. And the state secrets privilege means, again, they're trying to keep information from the court. B, the government has not shown reasonable danger of harm to national security from answering the discovery and deposition questions. So they're even continuing to fight the questions they've been asked during discovery. So number 1, this court must review the assertion of the state secrets privilege very carefully and with a skeptical eye. And the Rubio Declaration does not show that the privilege applies here. And I tell you, the more I hear and see about what Rubio's been doing in this situation, the more hinky it gets. I think that the Mr. Rubio here is on a hinky path. He seems to be incredibly powerful, much more powerful than perhaps his job really should be. And that's, that's worrisome. You give one person that kind of power and you're going to have some trouble. And I continue to see the executive orders setting out how much power he's supposed to have, and it just continues to just grow and grow and grow. So I think that's definitely an issue. I agree, Dania. That's exactly right. He's becoming a bigger player, right? You gotta watch, you gotta, stay grounded when you go through your stuff. So I think we're having some moments here where we're gonna start to see Mr. Rubio kind of turning an uncomfortable corner. And then see here, if there is any privileged information, it can and should be separated. So they're saying, well, fine, you want to have privileged information, just separate it out, but you need to answer everything else. And number 2, the court should overrule the deliberative process objections. 3, the court can review ostensibly privileged materials in camera. So they're saying if it is privileged, then the court can take a look at it in camera, which means in chambers. Like, they don't have to see it. You don't have to show it to us, but you do need to show it to the judge. So that's their basic outline here. Okay. Next up, a table of authorities here, which is pretty typical. Shady. Yeah, I agree. There's something weird going on there. I hope he's not like been, taken over. I don't even know what that means, but all I could think of was like, is he a pod person? Like, what's happened? Sometimes you just wonder. All right, I will start here by going through the introduction, and then we'll just kind of skip through and pick out the highlights as we go through this. But the introduction and then the pieces where they're trying to show that there's support for their argument, we'll hit on those points. All right, here we go. Introduction. A full month has passed since the United States Supreme Court found that Kilmar Armando Abrego Garcia's removal to El Salvador was illegal, and affirmed that this court properly required the government to facilitate Abrego Garcia's release from custody in El Salvador, and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Again, this is just to make sure we remember. This was filed yesterday. Yet Abrego Garcia remains in El Salvador, and the government has produced no evidence showing that it has made the slightest effort to facilitate his release. So that's good information to note. To the contrary, the president has insisted on national television that although he has the power to bring Abrego Garcia back, he won't, because his lawyers have advised him against it. That's very damaging information. And then footnote number 1, they're citing the interviews here. Other cabinet members, including the Secretary of Homeland Security, have likewise testified before Congress that, quote, there's no scenario where Abrego Garcia will be in the United States again. Footnote 2, very suspicious. And then we're quoting Secretary Noam's testimony. That was pretty discouraging, her testimony, because again, they're just clearly saying we're not going to abide by the Supreme Court, is what they're saying. All right. Meanwhile, in sealed ex parte proceedings, the government presumably has told this court the opposite, and it has repeatedly sought to draw out this litigation. True story. Plaintiffs have sought discovery to uncover the truth as to the government's efforts or lack thereof, as well as its abilities to facilitate Abrego Garcia's return. The essential issue in this case, over and over, the government has stonewalled plaintiffs by asserting unsupported privileges, primarily state secrets and deliberative process, to withhold written discovery and to instruct witnesses not to answer even basic questions. Man, that's one of my biggest pet peeves, is when you are in a deposition, which takes forever to schedule. Get everybody scheduled together and then get a court reporter in there. And then you get all of your questions set and you're ready to go. And you're like, okay, state your name. Like, oh, I don't have a name. Like, what? State your name. And they're like, I'm not going to answer. Fifth Amendment privilege. Like, that is not privileged information. But that is so frustrating. Even as the government speaks freely about Abrego Garcia in public, in this litigation, it insists on secrecy. So that's the difference too, if they speak in public versus if they're speaking in a deposition under oath. The Supreme Court directed the government to share what it can concerning the steps it's taken and the prospect of further steps, but it has shared almost nothing, in part because of privilege assertions this court previously found specious. That is no accident. The Secretary of State announced at a cabinet meeting while seated next to the president that he would never tell a judge whether the government had formally requested that El Salvador return Abrego Garcia. Ooh, sketchy, sketchy. And then there's a citation here. On its face, there's little reason to believe that compliance with a court order to facilitate the release and return of a single mistakenly removed individual so that he can get his day in court implicates state secrets at all. No military or intelligence operations are involved, and it defies reason to imagine the United States' relationship with El Salvador would be endangered by any effort to seek the return of a wrongfully deported person who the government admits never should have been removed to El Salvador in the first place. The government does not come close to making a showing that would disturb the common sense conclusion that there are no genuine state secrets at play here. First, neither the Department of Homeland Security nor the Department of Justice have lodged formal claims of privilege from their department heads based on actual personal consideration by those officers. Citing the case law here, that absence is dispositive for those two agencies. So the DHS and the DOJ defendants cannot rely on the privilege. Second, the declaration by Secretary Rubio for the Department of State fails to show a reasonable danger of harm to national security. This court must review Secretary Rubio's assertion of the state secret's privilege with a very careful, indeed a skeptical eye, and not accept at face value the government's claim or justification of privilege. Citing case law. And that's understandable. I mean, he's a little suspicious right now, the Rubio. The Rubio declaration's vague and boilerplate justifications do not satisfy this exacting standard. The fact that the government has repeatedly publicized information in congressional testimony, public interviews, and social media posts about Abrego Garcia and its unwillingness to facilitate his return confirms that answering the requested discovery would not imperil national security. More likely, the government's assertion of state secrets is consistent with an effort to avoid judicial scrutiny of its actions. True. The deliberative process privilege is likewise inapplicable for at least 3 reasons. First, the privilege does not apply, whereas here there is reason to believe that government misconduct has occurred, citing case law. Second, this privilege yields, whereas here plaintiffs have a compelling need for the discovery, citing case law. Third, the government has not carried its burden of showing that the requested discovery is deliberative and pre-decisional, as is required for the privilege to apply. In sum, the court should hold that neither the state secrets privilege nor the deliberative process privilege shields the government here from answering plaintiffs' basic discovery requests and deposition questions about the government's facilitation efforts and abilities, efforts that the Supreme Court itself ordered the government to share. And then we have footnote 4 here. Plaintiffs reserve all rights to challenge other privilege assertions by the government. Right. Every new filing on his behalf. He's got a team. And we love to see that. We really love to see that. I had just done a post earlier on Mr. Khalil, which I'm sure I'm saying his name wrong, but he was the Columbia graduate student who was outspoken and was pulled off the street. And this was in March. And there were some questions about who his counsel was, but then finally they got a really good team together. But he's still in detention. And I have to say, the attorneys in this particular case, I think are doing a spectacular job. They're doing very good work here. All right, so let's skip through a little bit. We've got the background, which we pretty much have gone through repeatedly here regarding the U.S. Supreme Court. So let's kind of hit here onto the redacted pieces. So in response to nearly every question, the government raised boilerplate privilege objections, and then they're giving those examples. So boilerplate, a privilege objection would be something like, we object privileged based on national security, or something along those lines, is how that objection would go. Objection, privileged information. Objection, privileged national security, privileged foreign policy. That's how that's going to go. So that's what's being said here over and over and over again. Boilerplate's just meaning like it's just the same objection over and over and over again, and it's just very generic. So there's no specificity to it. So rather than saying something like, well, this is something that is, covered by blah, 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 they're just saying, nope, objection. Let me bump back up here because this has a request for a production question in it. Plaintiffs promptly served discovery requests, including interrogatory numbers 1 through 7 and requests for production of document numbers 1 through 4, which seek discovery about the government's effort to facilitate Garcia's release and return to the United States, and interrogatories 9 through 11, and document requests numbers 6 through 8, which seek discovery about the government's agreement, arrangement, or understanding with El Salvador related to Abrego Garcia's detention in El Salvador. So that's what we're talking about. The exact thing that they are asking in these depositions is, are you complying with the Supreme Court order, and how are you complying? So that's a huge issue. So basically they're just doing random objections. Sometimes our objections during depositions, because you just want to get it on the record, typically you would object, but then the other person would still have to answer it. But in this situation, they're just saying, well, like, we're not going to answer it. So it's basically like saying, I plead the fifth, I plead the fifth, I plead the fifth. But it's along those same lines. On April 22nd, the court overruled most of the government's objections because they reflected a willful and bad faith refusal to comply with discovery obligations. Now, we didn't know that before. This is new information where they've taken these objections to the judge, and she said, you are refusing to answer in bad faith, relied on an arbitrarily cramped reading of the court's order. So again, we have that manipulation of words, or involved spacious and boilerplate privilege assertions. The court directed the government to supplement its responses with a specific legal and factual basis for each asserted privilege. So that's kind of a thing. All right, if you're going to claim a privilege that keeps you from having to answer a question, you're going to have to say what privilege it is. You can't just say, well, it's just a privilege. And like overwhelming, this DOJ is repeatedly just saying, well, because we said so, because we say it is that way. Like, that's not how the law works. You have to support what you're saying. So that's an issue. And produce a privilege log that fully complies with the federal rules of civil procedure and the court's local rules. And I think that was filed today. That may have been filed just a couple hours ago, this privilege log. And warned the government that if it did not, it would lose the protections it failed to properly invoke. So she's saying, if you don't put your privilege log in and do this correctly according to the rules, you're not going to be able to plead your privileges. The court also ordered plaintiffs to refine their requests about the El Salvador agreement to focus specifically on any agreement, arrangement, or understanding between the United States and El Salvador related to the removal and confinement of Abrego Garcia and any other individuals who were transported with him on March 15th of 2025. Yeah, I mean, if we just got on Signal, we'd be all right. But alas, plaintiffs served amended discovery requests later on April 22nd. The next day, the government moved for a stay of discovery, and the court granted a stay until April 30th. On April 30th, the court denied a further stay and ordered the government to answer and respond to all outstanding discovery requests and supplement its invocation of privileges consistent with the court's order by no later than Monday, May 5th. Wow, they even got a stay on that already? And they asked for another one? Oh my gosh. On May 5th, the government served objections and responses along with a privilege log and a state secrets declaration from Secretary of State Rubio. Here, once again, the government, I bet I can figure out, once again, the government used the same exact objections, didn't do anything or support the reasons for their objections. There we go. Meanwhile, plaintiffs deposed 3 DHS personnel, 2 on April 22nd. Evan Kotz and Joseph Mazzara, and a third on May 7th, Robert Cerna. At the depositions, stuff happened that they've redacted. Oh dear. Oh, so we don't know what was said, and that's okay. And then more was said. Also on May 7th, the court ordered the parties to file by May 12th formal briefing of the defendant's invocations of privilege, principally the state secrets and deliberative process privileges, as discussed in filing number 112. With the briefing to address the legal and factual basis for the invocation of those privileges, including plaintiff's request for the court to conduct in-camera review of the withheld documents. Plaintiffs respectfully submit this brief in accordance with the court's May 7th order here. All right, next we've got the argument. We'll just kind of skip through this a little bit too. So our argument, our first one is the court should overrule the state secrets objections here, that DHS and DOJ have not properly invoked the state secrets privilege, which, surprise, surprise on that one. So they're setting out that argument, and I'm not sure if they're actually going to have a hearing to debate whether or not that issue can be, whether that privilege can be used or not. That would be really interesting if the judge calls for a hearing. Accordingly, the court should reject the government's efforts to hide behind the state secrets privilege and compel all defendants from DHS and DOJ to fully respond to written discovery and all deponents from those departments to fully answer deposition questions. So again, they're just kind of, messing around with everybody. So the United States Supreme Court says you need to facilitate, and they're like just, dancing around like, ha ha ha, we're not going to answer that question. It's like a bunch of frat boys. They're just, not the fun frat boys, like the crappy ones. B, the government's not shown reasonable danger of harm to national security from answering the discovery and deposition questions. So again, there's certain standards. You can't just randomly say, well, it's privileged. You actually have to support that. You have to say, well, it is privileged. Well, how? How is it privileged? How is this a part of national security? And they're saying Rubio is not meeting that standard. The court must review the assertion of the state secrets privilege very carefully, right? And that's according to case law here. And I'm going to skip through that argument as well. Number 2, the Rubio declaration does not show that the privilege applies here. So that looks interesting here. Applying this exacting scrutiny, the Rubio declaration fails to satisfy the government's burden of establishing that there's a reasonable danger that compulsion of the evidence at issue will expose matters which in the interest of national security should not be divulged. So they're saying you just aren't supporting your request here. You don't have any backup for what you're saying, which, surprise, surprise again, right? Ooh, here we go. Look, we've got pictures. We love the visual aids. And I think this idea of going after the argument of, well, you're not telling us in a deposition, meanwhile, you're going out into the media and saying all kinds of stuff, I think is a really brilliant way of doing it. Because, of course, what do you mean you won't tell us? You just told everybody else. So here, over the past several weeks, the government has officially and repeatedly discussed its opposition to Abrego Garcia's return, so it cannot now claim that such information is a state secret, rather than steadfastly refusing to confirm or deny the accuracy of public speculation about its efforts to facilitate Abrego Garcia's release from custody in El Salvador. The government has publicly and prominently discussed its efforts. For example, April 16th, the defendant, Attorney General Bondi, stated, "He's not coming back to our country. President Bukele said he was not sending him back. That's the end of the story. If he wanted to send him back, we would give him a plane ride back. But he's from El Salvador. He's in El Salvador, and that's where the president plans on keeping him." Man, I tell you what. Rude. April 18th, the official White House account posted that, quote, "he's not coming back," end quote. Again, and we've just got our citations here. Oh, and by the way, he's not coming back. And then we've got the New York Times down here. Man, these people. Like, if you're really trying to be successful, you can't just confess all over social media. President Trump stated in a public interview, question, have you asked President Bukele to return him? I haven't. He said he wouldn't. Did you ask him? But I haven't asked him positively, but he said he wouldn't. But if you haven't asked him, then how are you facilitating his release? Well, because I haven't been asked to ask him by my attorneys. Nobody asked me to ask him that question except you. My goodness gracious. You could fix this simply by bringing him back and going through the legal process. But I leave that decision to the lawyers. At this moment, they just don't want to do that. They say we're in total compliance with the Supreme Court. Your lawyers are dingleberries. There, I said it. All right. On April 29th, President Trump stated in a public interview, you could get him back. There's a phone on this desk. I could. You could pick it up, and with all, I could. The power of the presidency, you could call up the president of El Salvador and say, send him back right now. And if he were the gentleman that you say he is, I would do that. But he's not. But the court has ordered you to facilitate his release. Goodness gracious, everybody. Was he like 5? Actually, I know some 5-year-olds more mature. I'm not the one making the decision. We have lawyers that don't want to do this. Dude. On May 2nd, the official DHS account posted that Abrego Garcia, quote, will never be allowed to return to the United States, end quote. Also on May 2nd, the official DHS account posted that Abrego Garcia will not return to our country under the Trump administration, end quote. On May 4th, President Trump stated in a public interview, question, just to put a fine point on this, do you have the power to bring Abrego Garcia back as the Supreme Court has ordered? Well, I have the power to ask for him to come back if I'm instructed by the Attorney General. If you're instructed, wow. Oh my gosh. I think we've got like a... I don't know. I'm going to keep my thoughts to myself on that. All right. I was thinking something that I shouldn't say out loud, so I'm not going to. If I'm instructed by the Attorney General that it's legal to do so, but the decision as to whether or not he should come back will be the head of El Salvador. Is anyone in your administration right now in contact with El Salvador about returning Abrego Garcia to the United States? I don't know. You'd have to ask the Attorney General that question. On May 8th, Defendant Secretary Noam testified in a Senate hearing. I assume you've read the Supreme Court decision in the case of Kilmar Abrego Garcia? Yes. I don't think that's true. That court decision requires the administration to facilitate Kilmar Abrego Garcia's release from El Salvador. Can you describe the steps that you've taken to facilitate this release? And specifically, can you answer as to whether you've reached out to your counterpart in El Salvador to facilitate Mr. Abrego Garcia's release? Abrego Garcia is a citizen of El Salvador and should never have been in this country and will not be coming back to this country. There's no scenario where Abrego Garcia will be in the United States again. And then she said, excuse me, I need to go take care of some puppies. That's what she said. Both the United States and El Salvador have also officially discussed their agreement in which the United States pay El Salvador to house its detainees for 1 year, for example. So this is very damaging information as well. On February 3rd, the official account of President Bukele posted that El Salvador offered the United States of America the opportunity to outsource part of its prison system, and that El Salvador was willing to take in only convicted criminals, including convicted U.S. citizens, into our mega prison in exchange for a fee. Also, February 3rd, Secretary Rubio publicly announced an agreement with El Salvador in which President Bukele agreed to accept for deportation any illegal alien in the United States who's a criminal from any nationality, be they MS-13 or this one, and house them in his jails. On March 28th, Secretary Rubio stated in a public interview, I can tell you that the agreement to house criminal aliens was reached with President Bukele back in February. And so we spoke. I've spoken to him since then, but obviously those days that I was there, we did, because we had a couple of open questions that we wanted answers to, and that he wanted answers to, and we were finalizing that. Man, something else. Given this extensive official public record that the government has created about its efforts to facilitate or not facilitate Abrego Garcia's return to the United States, as well as its agreement with El Salvador to house detainees, Secretary Rubio's assertion of state secrets privilege over these topics cannot be credited. And I would have to agree. Yes, he was here. He had an order saying he was not to be removed. So that court order was violated by the government. And then the U.S. Supreme Court said facilitate his return. And that court order is being violated by the government. Right. All right, next up. If there is any privileged information, it can and should be separated. So again, we have this situation where the plaintiffs are like, look, if it's privileged, it's privileged, then separate it out. But you need to give us the rest of the information that's not privileged. Not all the information is privileged. And I've kind of set this out before when we're talking about privileges. It can get kind of tangled up because some people think that a privilege means that nothing then can come in. But for example, let me explain it a little different. If you're in court and you're testifying, all right, you're a witness, you're testifying, and the question is, were you at the pub on Friday the 13th? And you say, yes, I was. And then they say, were you having an alcoholic beverage? And if you answered yes to that, you will be in violation of your probation or your parole, right? So you could say, this isn't legal advice, you could say, I'm going to take the fifth because anything I say could incriminate me, meaning your freedom could be at stake because that could be a probation or parole violation if you were consuming alcohol. Most people just say no, but I'm just trying to give you an example here, okay? So you're saying, look, the Fifth Amendment, I'm no self-incrimination. So then what happens is the judge, at that moment, the counsel will say, that's not privilege. That's not covered by self-incrimination. You have to answer the question. And then there'll be an objection. And then there'll be a sidebar up at the bench. And they'll cover the mic and they'll say to the judge, the question is, has he consumed alcohol? His answer to that's not going to lead to something, loss of freedom. And then his attorney or whatever attorney is going to say, yes, if he says he did, his probation can be revoked and we're making a public record. And so the judge then is like, all right, 5-minute recess. So then the judge goes out and the judge comes back in and says to the witness, you do not need to answer that question. Your privilege covers it. Move on, counselor. And then the next question comes in. That's how privilege works. All right. That's how privilege works. So let's say you're still testifying. You're like, okay, I'm not going to answer a question about drinking alcohol because I don't want to have a problem with my probation. So the next question is, when's your birthday? All right. And that's just another way of building a foundation. And let's say you don't want to tell them your birthday because you're tired of testifying and you don't want them to have any more information. You're just being a jerk. So you're like, Fifth Amendment, I'm claiming Fifth Amendment, privilege against self-incrimination. I'm not going to tell you my birth date. So then there's an objection. And then they go to the sidebar again and they talk to the judge. And they say, we're just building a record here. We're introducing him to the jury. There's no reason why his birth date could be used against him. It's all over all of the other records anyway. All right. And then the other person's like, well, if you give his birth date, then it could somehow lead to criminal charges. So the judge is like, 5-minute recess, goes away, comes back, and then comes in and says to the defendant, or says to the witness, the Fifth Amendment privilege does not apply here. This is not incriminating information. You need to answer the question. And then the witness says, well, I'm not going to. And then the judge says, you need to answer the question. It's not privileged. You need to answer it or you're going to be in contempt of court. And so the person says, well, I'm still not going to answer it. And so then the judge says, are we going to have to take you to jail? And then the witness says, well, I don't care what happens. I'm not going to answer it. And so the judge says, all right, bailiff, we're on recess until tomorrow. Put this guy in the slammer. And so then off you go, get taken to jail. Then the next day you come back. And then counsel comes up and says to you again, what's your birthday? And you say, well, I don't want to answer that. And the judge says to you, if you don't answer this, you're going to be in contempt of court and you're going to be looking at 30 days. And so then you say, January 1st, 2004. And then the next questions happen. All right. So see how that works? That's how you use a privilege. You put the privilege out there, and then the court determines whether or not the privilege is applicable in that situation. And will either say, all right, that question doesn't have to be answered. That's covered by the privilege. Or will say, no, you are directed to answer the question. All right. Now, the scenario that I gave you involving the birth date was something that happened with a witness in the YSL case in Georgia. And this witness was such a tough, hostile witness, and they literally asked him his birth date, and he refused to give that information. And the court was like, that information is not privileged. You cannot use the privilege to keep you from answering that question. All right, so did everybody follow me down that journey? I'm just hoping that's okay. Everybody kind of got that. So it doesn't matter who you are or what you're doing. If you're asserting a privilege, it has to be approved by the court. Okay, yeah, the YSL situation. Yowzers, that was crazy. Okay. All right, so the point again, though, is just because you say it'll incriminate me doesn't mean that automatically, all right, well, you don't have to say anything. What has to happen is the judge has to make the decision about whether or not the privilege is applicable. He was annoying, Jennifer. Oh my gosh, he was so annoying. Ooh, that witness was a tough one. That was a real tough one. I felt bad for the prosecutor in that situation. All right, so here we go. Now the court should overrule the deliberative process objection. So here, the deliberative process privilege does not apply where there's reason to believe the government has misconduct. Now, if you can't use a privilege because of misconduct, that's pretty bad. That's pretty bad. You're in a pretty bad standing with the court. So they're going through second and third about not being able to use that, again, because of bad faith. Now, if you do something too, a lot of people are saying, well, they're doing all of these really crappy things and not getting called out about on it. But it does actually negatively affect your case. If the judge is saying you're acting in bad faith or is making comments like, we can't trust what you're saying, those kinds of things can very negatively affect your case because here there's a privilege, there's a defense that's unable to be utilized because you've acted in bad faith as the attorney. So that's another accountability prong. Lastly, the court can review ostensibly privileged materials in camera. Again, just saying, fine, if you want to claim it's privileged, that's fine. You still need to show it to the judge in chambers. And then that takes us to the conclusion. For the reasons set forth above, the court should reject the government's assertion of the state secrets and deliberative process privileges. So this was, again, filed, counsel for plaintiffs here on May 12th, so just yesterday. Now, again, today, there was a couple of filings on the Garcia case that involved the privileges list. So it looks like they filed another explanation for why they get to use the privileges. And then there were multiple what am I trying to say? Oh my gosh, the third live today, everybody. The third live today. Let me double check. Let me check and see. I'm like, what was the other thing? Pro hoc vices. Sorry, my bad. So there were pro hoc vices. Pro hoc vice. Is it hoc or hack? I don't remember. Vice. So this is where most attorneys, you're not going to find a lot of attorneys that are like, oh, my primary purpose is just practicing in federal court, because you're going to practice in state court and in federal court typically. You might pick a few federal cases up, but your primary focus typically is not going to be federal court. There's just not enough cases to go around. So when you ask to come in as pro hoc vice, you're basically saying, I'm dependable, I'm reliable, I don't have any problems on my record. I practice in the state all the time. I want to go to the federal, court so that I can argue this particular case. And then you can be approved or not approved. Putting in the work today. Oh my goodness gracious. Yes. Oh my gosh. Yes, right. So the Pro Hoc Vices have been approved. We do have a couple other filings that have gone through, but that's about it, everybody. I mean, that's the latest. So as of yesterday, when this was filed, the plaintiffs have made it clear the government is doing nothing, absolutely nothing to facilitate his return. They're clearly in violation of the Supreme Court order, and of course the district court's order as well. So they've made it pretty clear in this filing here. So for anyone who's like, well, maybe they're working on it behind the scenes, no, they're not. They're not working on it behind the scenes, and so that's a problem. That's a big problem. Thank you for all of your. Oh, of course. Yeah, no problem. Actually, I will download my TikTok lives here tonight and then try to get them uploaded as quick as I can. For some reason, I just fall behind sometimes in getting those uploaded, and I think it's because it just takes so long to get them up and running. But so that's the update here on Garcia, everybody. Hopefully that was informative for you. You gained some information. You have some idea of what's going on. I'll keep everybody posted on Garcia. And again, I am doing my posts to YouTube as well as to TikTok. And then Tuesday nights, I am doing my For Sure lives here over on the tube. So I will do some kind of last minute thrown together bonus lives over on TikTok if something just drops. So if there's some orders or something very interesting that drops, then I'll just kind of jump on. But yes, so, and I'll have to take a look at that. I'll have to take a look at her order. I'm very thankful for her because of how she writes, and she does amazing work. So she was the judge in the Perkins decision, if I recall correctly. So Megyn Kelly's trying to weasel. Oh, really? No. Oh my gosh, goodness gracious. Noam said they weren't going to do anything. Well, exactly right. And so that's basically a confession. She basically testified in front of Congress, I'm not going to do what the Supreme Court is telling me I have to do. So that's kind of a big deal. It's kind of a big whoop-de-whoop-dees here. So we shall see what happens. I'll keep you posted, everybody. I best go and rest my voice. I can feel it starting to crack a little bit. So thank you so much for coming and hanging out with me. I will be here for sure next Tuesday, again, to do a live here on the tube for sure. But if you've got any questions, make sure just ask them on any of my posts, and I can let you know what's going on. So good night, everybody. Good night, John, June Marie, Bobby. Have a great night. Meme NATO. That's so funny. I love that name. Yes, take care, Navy vet. Make sure you're getting some rest. Everybody, take care of your mental health. Very important right now. And I'll see you all again very, very soon.